Okay, good afternoon and welcome to the final of the National Speed Mooting Competition Winter Cup on the 12th of December 2020. So we're up to the final round now, and the final is between Luke Austin and Adam Smith. Luke will be representing the appellant and Adam will be representing the respondent. Luke, when you're ready, in your own time, you can begin your submissions.
My lords, I appear on behalf of the appellant, Mr. Miller, who's the defendant in this matter. My learned friend appears for the respondent. Can I assist the court with a brief opening of the facts?
No, we're cognizant of the facts, thank you.
I'm grateful. My lords, my ladies, I'd like to start with a brief discussion on the special reasons test itself, before moving on to two key submissions. The first being that the factual matrix of this case is very similar to that in DPP and Cox from 1996, which was reported in the road traffic reports at 123. And with the court's permission, I'd like to dispense with formal citation at this stage.
Yes, absolutely. Thank you.
I'm grateful. My second submission will be a consideration of the factors that it was said the court must consider in Taylor and Rajan. Moving to the special reason test itself, I'd like to take the court to the judgment in Evans and Bray, and the section that I would like to refer the court to is at page 35 of the bundle. And this is the judgment of Mr. Justice Donaldson as he was then. And the section that I'm interested in is the second to last paragraph, which starts with the justices. Are your lordships with me? I'm grateful. My lords, this sets out the test to be considered today. Here it says the justices have said his action was understandable, and that in that case it was not dissented from, but clarifies that that is not the test. Rather, the question is whether, in all the circumstances, his conduct was such that it can be said there were special reasons justifying a failure to disqualify. And what I submit is that means it's a wide consideration of the factors on that day and takes into account all of the circumstances as to whether Mr. Miller should be disqualified. Moving then to my first point, which is a consideration of DPP and Cox. Just as a way of background, that case, you may be aware of it, involved a lady, a mother who was in the pub one evening. Her babysitter received threatening calls and therefore rushed home to deal with that. My apologies, no, sorry, I'm referring to DPP and Cox, my apologies, your lordships, which was a similar factual case of a key holder relating to a local golf club. If I may, I'd like to take you to that case in the bundle, in particular, page 20, where we find the judgment of Lord Justice McCowan. Are your lordships with me? Do you have it? I'm grateful. The third paragraph sets out the facts in that case. It says the defendant was the steward and key holder of Mooting and Norton Golf Club, and that the premises were 300 yards from his home. Further, in that paragraph, it says he had no intention of driving his vehicle that day and had no reason to think that he would be called to do so. Further, it says no thought to the amount of alcohol he'd consumed or to alternative methods of transport or to contacting key holders were given before he drove that day. Because they are very similar factual situations to what we have here. And in that case, it was found that the magistrates were in their right to consider that he should not be disqualified from driving.
Mr. Austin?
Apologies.
Just in relation to that case, that's quite different to the case that we have before us today. Mr. Miller drove further than the defendant in that case, and the circumstances, there were other vehicles on the road and he had a higher level of intoxication. Why should those principles still be applicable in this case?
My lordships, I would submit that because of the higher emergency that exists in this case, that greater lenience should be given to someone who decides to drive. In this case, we have a situation with potentially very dangerous chemicals that could cause damage to the building or in fact endanger life. Whereas in DPP and Cox, it appears that it was purely a theft situation. And so because of the levels of emergency, greater lenience should be given in this case.
Councillor, following directly on from that point, and from Chloe's point earlier, the case that potentially is more analogous to this one, given your own submissions, is that of Evans and Bray, where there was a threat to life as a result of the wife not having her medication readily available and her medical condition. In that case, the judges held that in such a situation, it was more appropriate to dial 999 and allow the emergency services to deal with such an issue. Why does that not apply in this case?
My lord, it's a useful point. I think the issue that we have here is that these chemicals, and it is an assumption, are assumed to be dangerous and that would require somebody with experience of dealing with those chemicals to be on scene. Whilst the police force clearly have expertise in those sorts of situations, having someone on the ground with specific knowledge of the layout of the laboratory, specific knowledge of the chemicals involved, would be of assistance to the police at that time.
And this could not be the appellant's sober colleague?
It could be, and my lord, it is a valid point that there was another key holder, Ms. Chung. What we see, however, in the authorities is that the timescales are important. If I may, I'd refer again to DPP and Cox, and in particular page 22. And in the final paragraph of that page. Do you have it, my lords? I'm grateful. Here it was pointed out that in that case, that it was it was not a static situation, it was a developing one. And that the situation at the clubhouse in DPP and Cox could have got worse by the minute. That is the case here as well, my lords, that those few minutes quicker that Mr. Miller could have arrived at the scene rather than Miss Chung could have made all the difference. And for that reason, it was justified that Mr. Miller decided to go straight to the scene rather than risk any delay in trying to firstly either contact Miss Chung or waiting for her to arrive.
I do apologise, counsel, for persisting with this point. However, in the case Park v Hicks, it was held that the onus is on the motorist to demonstrate that the emergency is an emergency that justifies such action as driving when intoxicated. And in that case, the evidence was held to be nebulous of a medical emergency. In this case, you have said there is an assumption of a danger from the chemicals. There could have been an explosion. Miss Chung's attendance could have caused an issue to arise. How is this case any less nebulous than that of Park and Hicks?
I think Park and Hicks, there was extremely limited information as to what the disturbance actually was. There's no specific facts given as to what the issue was in Parks and Hicks. Whereas here we do know that there was very dangerous chemicals involved. It's a balanced test, my lords. It's a consideration of the risk that Mr. Miller took in driving whilst intoxicated versus the risk of those chemicals exploding. And it's submitted that that high level of risk from those dangerous chemicals, a danger to life, outweighed the driving at that time. It must be recalled, my lords, that this is a road that Mr. Miller drives every day. It is a straight road. It is a short distance. And whilst he was intoxicated, he did stay under the speed limit. There are no suggestions that his driving was unsafe, and therefore in that situation and in those circumstances, it is submitted that his actions were justifiable and would amount to a special reason in this case. My lords, I'm conscious of time. Unless I can assist you further at this stage, that would conclude my submissions.
That's exactly 10 minutes. Thank you, Mr.
I'm grateful.
Austin. Mrs. Smith?
May it please the court. I wish to resist this appeal that the High Court's decision should be upheld and the special reasons should not be found on 3 grounds. These grounds are highlighted in my skeleton argument. Does the court have the skeleton argument to hand, and have they had sight of the papers? I'm grateful. My lords, if I may, I wish to focus my oral submissions on ground 1, that is point 2 of my skeleton argument. That the factors that the court must consider, as set out in Taylor and Rajan, indicate that on balance, a special reason was inappropriately found to preclude mandatory disqualification in this case. For your lordship's consideration, the factors are fourfold. Firstly, the nature and degree of the emergency. Secondly, whether alternative methods of transport or dealing with the emergency were available. Thirdly, the manner of the appellant's driving. And finally, the appellant's blood alcohol content. Now, my lords, I wish to address these in turn, if I may. Turning then to the nature and degree of the emergency. My lords, I submit that this is highly speculative regarding the exact extent of the potential danger. Indeed, in the appellant's own submissions, he used the words potentially, and that is, it is an assumption and that it could have been essential. But none of these are very hard and fast facts. Indeed, in the case stated, it is stated that the interference with the chemicals could cause an explosion, that they could potentially destroy the lab, and they could potentially cause damage to the surroundings.
Counsel, if I might, just early on in your submissions ask, at what point then would a potential loss of life, in your opinion, justify, or in your submissions, justify the actions taken in the present case? Because though this loss of life was potential, it was also great. A potential chemical explosion is nothing to be sniffed at.
My lord, you muted yourself at the end.
Apologies, did you not catch the end of that? I said a potential chemical
No,
explosion is nothing to be sniffed at.
Indeed, my lord, the only issue there is that there would be a greater chance to, a greater justification for taking the risks as the appellant did, with greater certainty that the chemicals were in such a way that any break-in would have caused an explosion, as opposed to may have. Indeed, in this particular laboratory, there were these chemicals only in one place of the room. One place of the building, which was one room of 10. There are multiple questions to be answered with regards to this, my lords. There just simply is not enough detail. And if this detail was provided, then it certainly would weigh in favour of the appellant in undertaking this risk. However, this is not the case. It is not stated at all, or not submitted, whether this particular room with chemicals was locked. It was never stated how long it would have taken the robbers or the intruders to get to the room with chemicals in it. And indeed, it's not stated that, I say this facetiously, but it has an important point. If somebody drove into the laboratory in drink driving, would that have in itself caused such an issue? But we do not know about the structural integrity of the building, and all of this detail could have been presented, but was not.
Mr. Smith, Mr. Miller might say, I know the risk. It's huge.
Indeed, indeed, my lord, but Mr. Miller did not put this in his submissions. He has not, following the case of Park and Hicks, if I may turn your lordships to that case, it was stated that there is far more detail that is needed for the court to ascertain the degree of emergency. Now, in that case, Detail wasn't provided, but they had an idea as to the nature of the illness and the nature of the remedy, but it was not exact. And these details, because even though they were known by the appellant in that case, they were known by the person in need of medication in that case, were nonetheless not put forward to the court for their consideration. And it is therefore because in this instance, these facts of degree and these facts of detail were not put forward, that the court must essentially not consider the risks as are stated by the appellant without evidence.
I think you should move on, Mr. Smith.
I'm grateful. If I may then turn to the second, very briefly on that last point, on the nature and extent, the nature and degree of the emergency. In the
I think you should move on, Mr. Smith.
I'm grateful. The alternative, turning then to the alternative methods of transport. My lords, there were multiple alternative methods of transport, and the amount of time taken to utilize any of these would have been minimal. The appellant's neighbor was a taxi driver. He could have made it to the lab almost in equal time as the appellant did, but for asking whether he could do so. Indeed, Ms. Cheng was only 5 to 6 minutes away. This is a matter of minutes more, and it would be wrong in my submission to consider 1 or 2 minutes in choosing not to contact someone who could have driven there sober, to then take the risk on yourself and drive drunk to go and resolve this issue. Moreover, the police were on their way, as the appellant knew, and he could have waited for them to come and take him with them. Indeed, his expertise in that area would have been useful, but nonetheless, he chose to take a risk on himself. But importantly, and in my submission, the most important consideration that was not taken was that the appellant could have run to the laboratory in under 4 minutes. Now, this was very much 1 minute more than driving. So the question for the court to answer in my submission is, was the matter of 1 or 2 minutes really worth potentially endangering lives en route? And this is to be considered in the fact that this must be objectively assessed. The situation as a whole, when considering the situation as a whole, driving by the appellant seems to be essentially just a convenience as opposed to a necessity. And importantly, in any case, it is my submission that the appellant should have at least considered these alternative means. If I can turn your lordships to the bundle at page 29, per Judge McKenna's argument in Taylor and Rajan, where it is stated, if your lordships are with me, it is stated that the circumstance that the defendant could have asked his father made it unreasonable for him to drive to the restaurant in his condition. On these facts, your lordships, he did not consider calling Ms. Cheng. He did not consider seeing if his neighbors could drive him. He did not consider running. Mr. Miller could have essentially undertaken any of these methods, but did not consider them when he certainly should have. Moving then to the third factor, the manner of the appellant's driving. There was, in my submission, traffic on the road, and this is significant enough to distinguish this from Cox. If I can turn your lordships to the first paragraph at page 21 of the bundle, and when your lordships are with me, it stated that the justices went on to find the fact that no traffic was on the road on the journey between the defendant's address and the club premises, other, it seems, than police vehicles en route. And this is hugely significant because the purpose of the drunk driving legislation is to prevent drunk drivers causing injury to road users, be that pedestrians or other drivers. The fact that there were other drivers found on this occasion, the fact that this was in a built-up area, presumably with people around, are hugely significant in the court's assessment of whether this action by the appellant was justified.
Counsel, you state that the purpose of the legislation is to prevent the risk to the lives of the public. Equally, however, we're obviously being asked to perform a balancing act between the risk to the lives of the driver and the risk to the lives caused by the explosion of the laboratory. What would be your submissions on how we approach balancing those two elements?
My lord, it is in balancing these, I believe it comes down to the first factor of Taylor and Rajan, which is looking at the exact detail of the nature and extent of the emergency and taking Park and Hicks into account when doing so to see that which element or which particular emergency is most substantiated. Indeed, the driving legislation was put in place because of statistics being so high in death by dangerous and drunken driving cases. And that is in itself speaks for the policy as having been thought through and considered, whilst the assertion by the appellant is that there is that there is a potential explosion. However, he has given no substantial evidence to reinforce that.
That's time's up. Mr. Smith,
Unless I
thank
may
you.
be of any further help, those are my submissions.
Thank you very much, both. That was excellent by both of you. As with all such cases, this is a factually difficult case. The court has been very specifically asked to balance the risk caused by an emergency situation with the potential risks caused to the public of the appellant's driving. The appellant has submitted that the danger to life of the explosion by far outweighs the danger caused by his own driving. It's in the court's discretion not to disqualify a defendant where they find a special reason that is adequate to justify the exercise of such discretion. And I find that the court in the first instance was right to consider that this emergency situation amounts to a special reason. The situation was a developing one, and one in which there was a potential significant risk to life and limb of members of the public. And though in this situation, the appellant had clearly not intended to drive and was compelled by the emergency situation, the onus is on him to clearly demonstrate that the emergency situation is such that it justifies us exercising that discretion. The presence of the special reason itself is not an automatic bar to disqualification. With regard to the nature of the explosion, it was highlighted by counsel that it is not clear from the appellant's evidence why there was a high risk of explosion. And indeed, as the respondent submits, and similar to the case of Parker and Hicks, the evidence in this particular case of the emergency is nebulous at best. It's also worth noting that the appellant had been drinking throughout the day and had an extremely high blood alcohol content. Indeed, his blood alcohol content was more than 4 times that of the legal drink-drive limit. As was stated in Taylor and Rajan and the Link case of Fraser against Barton, where there is a blood alcohol limit of above 200 micrograms per 100 ml, there is no situation that justifies an appellant driving. Importantly, given the level of the appellant's inebriation, the fact that the appellant did not consider a single alternative method, either of transport or of dealing with the emergency, is an extremely prescient point in this case. Alternatives, unlike in the case of DPP and Knight, were readily available, would have minimally impacted the appellant's arrival time. Additionally, he had a sober colleague at the other end of the road with the same level of experience as him, able to deal with the situation. It would not have assisted the emergency services or members of the public at risk from the explosion for him to have caused a second emergency by crashing his motor vehicle en route to the factory. Indeed, such a diversion of emergency services would potentially put even more people at risk. It was held in Evans and Bray that where there is an immediate threat to life, the emergency services are better placed to deal with that than the individual, and dialing 999 becomes the most obvious course. The appellant, if he was concerned about either the arrival time of the police or their experience to deal with the chemicals, could have contacted the police to inform them of the danger. There is no situation in which they would have advised him to attend in his state and to drive there to deal with the situation. So, despite the extremely well-framed submissions of the appellant and convincing submissions, Given the extremely high blood alcohol level of the appellant and the high risk posed by him of driving in along a busy public road on a Saturday afternoon, despite the multiple alternatives available, both in terms of transport and for dealing with the emergency situation, we find that the court was wrong to exercise its discretion and the appeal is dismissed.
First of all, dealing with the appellant, Mr. Austin, Luke, good pace, good structure. You outlined what you were going to do, talked about formal citations. So those are the positives. In terms of things that could be improved, be a lot more careful with language. You know, make it a bit tighter. So you said at one point, the section I'm interested in, rather than saying something like that, say, you know, the section I wish to draw your lordship's attention to, or remove yourself from that situation. You also said, you know, a higher emergency. Just be very careful. The reason to have a slow pace is to allow you time to think, not rush ahead. So just be very, very almost lumbering, you know, with your language. Think before you use a particular word so it doesn't appear loose. We thought you handled judicial interventions very well. You were asked at one point to talk about the case of Hicks and about facts being nebulous, and you did. You came right back that, which is great. But we would say, this is the headline for you, what you're doing as an advocate is helping the judge to arrive at a decision. That's why you're there. The judge needs to make a decision, and you're there to help them. And to do that, you have to persuade them. But one of the things you did was there was a lot in there about the facts, and a lot of discussion about the facts. And at this level, just assume we know it. You know, assume the judges know the cases. What they're interested in is, how are we going to arrive at the destination of the judgment, and help them to get there. Keep that at the forefront of your mind going forward. That's your role. You're there to assist the court to make a decision on this particular area of law. So by all means, the facts, yes, but at this level, not so much. It's not facts here. It's about the authorities and the principles that are going to help that judge make the correct decision. Okay, so that's your feedback. Does anybody else want to add anything to Luke before I move to Adam? No. Okay, all right then. So over to Adam. Begun very confidently. Again, really nicely phrased. I wish to focus my submissions on. Talked about the principles in Rajan and Taylor. I liked that you had, you know, variance, tone and color in your voice. You picked up immediately on the exact wording of Luke, picked up his exact words when you wanted to rebut them, which was good. It showed you were paying attention, which is what you'd have to do in real life, you know, be alert and paying attention to absolutely everything. You had a judicial intervention where you were asked to discuss facts, and you said, well, there's a distinction between something that would have happened and something that may have happened. That was very nice. In terms of things that could be improved, the first thing is, if a judge says move on, you just move on. Because, you know, again, they know these cases. When they ask you a question, it's because they already know the answer, or they just want to have that answer confirmed, or to be given something else to think about. And so you've given your answer, and Matthew said, you know, move on. You said, oh, can I just come back? Don't do that. You know, in real life, they just won't like it, really. Just assume that, you know, you're in their hands to do whatever they ask you to do. And if they say move on, just, you know, move on. They've got all the information they need. I would say, again, be slightly careful with language. You said at one point, this is hugely significant. You said presumably with people around. In my submission, there was traffic on the road. The main headline for you is root your submissions in reality. Try to tone it down a bit. You were very confident, but in terms of tactics in this kind of case, feel the vibe of the case in terms of whether this is a full throttle attack case, or in this kind of case, something that's very finely balanced, something where, you know, the person in the dock could almost garner some sympathy, you know, in human terms, not in legal terms, that people might think, when it's that sort of case, the submissions need to be more, yeah, I can see what happened here, you know, I accept that, you know, the appellant believes he acted in the way, but more in sorrow than in anger, I must, on the law, it just, you know, as much as I feel human sympathy, on the law, you know, this is it. He needs to be disqualified because the law says so. So be dispassionate, take yourself out of it. And just in this sort of case where it's finely balanced, tone it down a bit, you know, language, no hyperbole in terms of, as I say, hugely significant, just lower the temperature, because part of advocacy is also about feeling the judges, feeling the audience and what plays well. And in this sort of case, it's not, you know, a violent attack or something very controversial, but say if it was in a newspaper article, the public would get angry about, they wouldn't, they'd be kind of, you know, oh dear, some would say, oh, idiot, why did he take his car? Others would say, oh dear, what would I do? So tactically, a lot calmer in this sort of, if that makes sense. Yeah, does that kind of make sense? And yeah, so I had put, try not to be absolutist in your case, see the gray areas and lean to them, show the court that, yeah, you fully understand them, but yeah, you, the court, you've got no other choice. As much as you might feel sympathetic for this man, root your submissions in reality. Yeah, so just be careful of that. Don't make assumptions, presumably of people around. In my submission, there was traffic on the road. Stick to, just be straight. You've got all the facts there, you've got the authorities there, be straight. But apart from that, color, tone, variance, great. Yeah, headline for you, feel the mood of the case and judge your submissions accordingly.
We felt that the person who was slightly better and so therefore should win the moot is Luke.
Thank you very much.
Thank you.
Congratulations, Luke. Well done, Adam, as well, for reaching the final. I'd like to say that was a very closely fought final.
It was, and if we say why Luke just pipped it, it was in terms of dealing with judicial intervention.